For what purpose does Mr. Biggs seek recognition?
Move to strike last word.
Gentleman is recognized.
Thank you. I too rise in support of the amendment, and I'm stunned that we're having this discussion. I just have to point out, though, I mean, you have just short of 100 pages of guns that you're banning with this piece of legislation, and you're banning them from people who actually are in jeopardy, whether you live on the border, victim of domestic violence, or whether you have the skills and the trust of your government that of members of the armed forces on active duty or veterans. I don't want to belabor the point, but I will. The reality is when we talk about the cases that were cited, I'm going to ask Mr. Chairman if you will, if we can introduce into the record Judge Rules, U.S. Air Force largely responsible for Sutherland Springs shooting.
Without objection.
Thank you. Now, Mr. Gomer was exactly right. What happened here is you had a service member discharged because of crimes he committed, violent crimes he committed. And what the court said is that the U.S. government failed to report his criminal record, which would have otherwise prevented him from getting the gun when they did the background check. It isn't because he was a service member and committed a heinous crime. It was because the service itself failed to fulfill its duty. What we're talking about here tonight is basically saying to an incredibly large class of people that we expect to carry weapons after being fully trained, that you are unworthy. You are unworthy to represent and protect yourself. That's what we're saying here. And that is a disservice to the veterans in my community and the active service members around the world. I have a huge retired veteran population in my district. That happens in the Sun Belt. They love this country. They fought for this country. I still have veterans from World War II, all the way up to the most recent of conflicts. And the reality is, you shouldn't limit their right. You should not limit their right. And I would just say it's an interesting contrast to me that this administration, which would, if this gets to it, would gladly sign this bill, I'm sure, would leave literally billions of dollars worth of very dangerous weapons in the hands of terrorists like the Taliban, but we'd forbid them. We'd forbid our own veterans and armed forces on active duty from getting these types of guns that are listed in this nearly 100 pages in this bill. And so I think it's a travesty, and I urge adoption of this amendment, and I'll yield back.
Gentleman yields back. Does anyone else seek recognition? In which case the question occurs on the amendment. All in favor say aye. Aye. Opposed, no. No. In the opinion of the chair, the noes have it.
No.
A recorded vote is requested. The clerk will call the roll.
What we got there, that usher the next stage, that's three of my.
And someone will shut their mute.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No. Yes.
Ms. Lofgren
He
votes
made
no.
good time. Thank you, Mr.
Ms. Jackson Lee?
Hey, we got back. No.
Ms. Jackson Lee votes no. Mr. Cohen?
No.
Mr. Cohen votes no. Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries? Mr. Jeffries?
No.
Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Stimmings?
No.
Ms. Stimmings votes no. Mr. Correa? Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
Absolutely no.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
Dean votes no.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones?
No.
Mr. Jones votes no. Ms. Ross? Ms. Bush?
Last minute
Ms.
stuff.
Bush?
no.
Ms. Bush votes no. Mr. Jordan? Mr. Jordan votes yes. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Isa?
Aye.
Mr. Isa votes aye. Mr. Buck? Mr. Buck votes aye. Mr. Gates?
Aye.
Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stubbe? Mr. Tiffany?
Tiffany, aye.
Mr. Tiffany votes aye. Mr. Massey? Mr. Massey votes aye. Mr. Roy?
Aye.
Mr. Roy votes aye. Mr. Bishop?
Aye.
Mr. Bishop votes aye. Ms. Fishbach? Ms. Fishbach votes aye. Ms. Sparts? Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes yes. Mr. Owens? Mr. Owens votes aye.
Am I recorded?
Mr. Deutsch, you are not recorded.
No.
Mr. Deutsch votes no. Mr. Gomert, you are not recorded. Mr. Gomert votes aye.
Clerk will report. Has Mr. Raskin voted? Okay.
How am I recorded?
Mr. Raskin, you recorded as no.
Correct, thanks.
Mr. Chairman, there are 18 ayes and 22 noes.
The amendment is not agreed to. Are there any further amendments to the amendment nature of a substitute?
Mr. Chairman, I have a point of personal privilege, if I may.
What's the gentleman will state his point of personal privilege?
I would ask the chair to strike Mr. Cohen's vote for failure to adhere to the chair's advice on appropriate attire.
The chair can advise members of appropriate attire, but I cannot strike his vote. If there are no further amendments to the amendment nature of a substitute, the question occurs on the amendment nature of a substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye. Aye. Opposed?
Aye.
Opposed,
Aye.
no.
Aye.
In the opinion of the chair, the ayes have it. The amendment nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the bill H.R. 1808 as amended favorably to the House. Those in favor respond by saying aye. Aye.
Aye.
Opposed, no. The ayes have it, and the bill is ordered reported favorably. Roll call is requested. Clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren?
Aye.
Ms. Lofgren votes aye. Ms. Jackson-Lee?
Aye.
Ms. Jackson-Lee votes aye. Mr. Cohen?
Aye. This is a 40 regular.
Mr. Cohen votes aye. Mr. Johnson of Georgia?
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch?
Aye.
Mr. Deutsch votes aye. Ms. Bass? Ms. Bass?
How's the chair voting? Hello?
Ms. Bass, yes. This is final passage.
Yes. How's the chair voting?
The chair voted aye. This is final
Bass
passage of the
votes
bill.
aye.
Ms. Bass votes aye. Mr. Jeffries?
Aye.
Mr. Jeffries votes aye. Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell?
Aye.
Mr. Swalwell votes aye. Mr. Liu? Mr. Liu? Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Stimmings?
Aye.
Ms. Stimmings votes aye. Mr. Correa?
Pamela.
Ms. Scanlon? Ms. Scanlon votes aye. Ms. Garcia?
Tell Pamela.
Absolutely yes.
Ms. Garcia votes yes. Mr. Neguse?
Aye.
Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Dean is delighted to vote aye. Thank you.
Ms. Dean votes aye. Ms. Escobar?
Yes, yes, yes.
Ms. Escobar votes yes. Mr. Jones?
Aye.
Mr. Jones votes aye. Ms. Ross? Ms. Bush?
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan? No. Mr. Jordan votes no. Mr. Shabbat? No. Mr. Shabbat votes no. Mr. Gomert? No. Mr. Gomert votes no. Mr. Issa?
No.
Mr. Issa votes no. Mr. Buck?
How is the chair recorded?
Chair is recorded as aye.
No?
Mr. Buck votes no. Mr. Gates?
No.
Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock?
No.
Mr. McClintock votes no. Mr. Stubbe? Mr. Tiffany?
Tiffany, no.
Mr. Tiffany votes no. Mr. Massey? Mr. Massey votes no. Mr. Roy?
No.
Mr. Roy votes no. Mr. Bishop?
No.
Mr. Bishop votes no. Ms. Fishbach? No. Ms. Fishbach votes no. Ms. Sparts? Ms. Sparts votes no. Mr. Fitzgerald? No. Mr. Fitzgerald votes no. Mr. Benz? Mr. Benz votes no. Mr. Owens? Mr. Owens votes no.
Ms. Ross?
Ross votes aye.
Ms. Ross votes aye.
Correa votes aye.
Mr. Correa votes aye.
Mr. Chairman, how am I recorded?
Ms. Jackson Lee, you recorded as aye.
Are there any other members who wish to be recorded who haven't been recorded? Clerk will report.
Mr. Chairman, there are 25 ayes and 18 noes.
The ayes have it, and the bill is amended as ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 2814, the Equal Access to Justice for Victims of Gun Violence Act for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2814, to repeal the protection of lawful commerce.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. We are a country with a robust civil justice system where people, no matter their age, wealth, or education, can bring a lawsuit against those who have caused them harm and hold them accountable. That is, unless those harms are caused by the gun industry. In 2005, Congress passed the Protection of Lawful Commerce in Arms Act, or PLCAA, which effectively extinguished the protections that victims of gun violence could receive through the civil justice system. And with it, any hope for victims to recover damages when they or their loved ones are injured by firearms. We are here today to right those wrongs. H.R. 2814, the Equal Access to Justice for Victims of Gun Violence Act, would restore the rights of victims of gun violence to hold the firearm industry accountable when it acts carelessly and disregards reasonable safeguards that would protect the American public. Civil litigation is a critical tool to incentivize industry actors to act responsibly, to take steps to prevent negligent or criminal use of their products, and to improve product safety. But the PLCAA foreclosed that possibility with respect to the gun industry, and only the gun industry. An industry that has no fear of being held accountable will devolve into a market that rewards the lowest common denominator. The system created in 2005 disincentivizes responsible behavior and allows companies that ignore safety concerns and act unreasonably to profit from outrageous behavior. Instead of seeing safety mechanisms evolve in the marketplace over time, we have seen guns reach our communities that pose an increased danger to their owners, their families, and countless victims of gun violence. Dealers have no incentive to avoid negligently selling firearms to traffickers, and manufacturers have doubled down on advertising to children and ordinary civilians for so-called urban warfare scenarios. Today's gun industry innovates for lethality, not for safety. Manufacturers have designed guns to accept ultra-high capacity ammunition magazines and built-in military-style features to make their guns more concealable, controllable, and maneuverable in close quarters, like classrooms and nightclubs. And they have marketed those weapons with militarized images and language. Closing the courthouse doors denies some gun owners and all innocent bystanders the opportunity to seek justice for themselves, their loved ones, and their communities. And denies America a future without the specter of a mass shooting looming over every single public gathering. 17 years after PLCAA became law, the story of the gun industry is not one of evolution and innovation, but one of greed and recklessness, one that is responsible for lives snuffed out all too soon or forever changed. We must have a measure of accountability for the parents of little children who will never have another birthday party or surviving classmates who are too traumatized to return to their schools. The concert goers and parade goers who will never walk or dance again. The countless high school students coping with traumatic memories more reminiscent of war zones than classrooms. The grandparents who must now raise their grandchildren while mourning the loss of their own child. All of these individuals had something precious taken away by a person with a gun, and they all had their right to hold the gun industry accountable taken away by Congress. The Equal Access to Justice for Victims of Gun Violence Act would restore that right. In addition to repealing wholesale immunity for the gun industry, H.R. 2814 would also allow crime gun trace data from the Bureau of Alcohol, Tobacco, and Firearms firearm trace system to be used in civil and administrative cases. By rolling back the ban on the discoverability of this data, this bill would allow victim litigants to access, disclose, and use this crucial data as evidence in the course of civil litigation or administrative proceedings. The gun industry enjoys legal immunity unmatched in the United States today. PLCAA has provided unprecedented insulation to the gun industry for dangerous business practices that no other industry in the United States enjoys, and it has denied justice to countless victims and survivors of gun violence, preventing recovery from damages wrought by the dangerous marketing and sales practices of the gun industry. Today, we take the first step to undo the damage done by that law and rebalance our civil litigation system to resemble what the founders intended. It is past time that we put our trust back in the legal system, not in the gun industry. I commend Representative Adam Schiff for introducing this timely legislation, and I urge all members to support it. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Before I do my opening statement, earlier today we had a gentleman disrupt the proceedings of the committee, specifically disrupting the presentation from Congressman Biggs. And I asked the question if how did this gentleman get in the room? Who was either the guest of or who met him at the door? And you said you didn't know. And it's been about 11 hours since that happened. I just was inquiring if the chairman would tell us how this individual got into the committee hearings and was able to disrupt that. Who was he a guest of?
If the gentleman will yield.
I'd be happy to yield. So I
I've
asked the
been in
question.
the committee room sitting here the whole time, and I still do not know.
Well, someone had to meet him because the way the rules are, you have to meet someone at the door to bring them into the Capitol complex, into the office space, into committee hearings. And we'd just like to know who that was.
I don't know.
Well, can you find out? We've been all day. I checked with our members. None of them met him at the door. None of them brought him in. So we know no Republican did. Someone did.
Gentleman has the time.
Will you give us an answer, though, Mr.
I
Chairman?
don't
That's my
have an
question.
answer.
No, you may not have one now. It's been 11 hours. Maybe it's going to take you 11 more, maybe tomorrow. But will you give us an answer sometime soon?
If I find out.
Will you check it out? Is what I'm asking, for goodness sake.
If I can.
Okay, God bless you. We appreciate that stellar effort. The last bill was about legislating away your Second Amendment rights. This bill is about litigating away your Second Amendment rights. The Protection of Lawful Commerce in Arms Act was passed in 2005 with significant bipartisan support in both chambers of the United States Congress. That law made clear what many courts already recognize and what is just plain common sense, that manufacturers should not be forced to litigate frivolous lawsuits based on the criminal misuse of their products. This was the state of the law until the 1990s, when, as the National Rifle Association pointed out, a group of attorneys and politicians set out to use the tort system to achieve the gun control policies that had been rejected by state legislatures and the Congress. Today, Democrats are trying to do both in one committee hearing. The PLCAA was passed in 2005 in response to this effort. When Congress passed this law, 59 House Democrats and 14 Senate Democrats, including Democrat leader Harry Reid, supported this legislation, which sought to, quote, end a barrage of civil claims brought by shooting victims, their families, and municipalities aiming to hold the gun industry liable for the personal and public cost of firearms-related violence, close quote. 59 House Democrats supported this policy. As we said, it just goes to show you how radical the Democrats in the House are today. But for the progressive Democrats in charge today, the bill before us isn't about litigation reform. This is about attacking fundamental constitutional rights. As Democrats take away your guns, they want to unleash an army of trial lawyers to sue good American firearms manufacturers and make it hard for gun manufacturers to do business in the United States. The Democrats' real goal here, as the NRA has explained, is to bankrupt the firearms industry through endless, meritless lawsuits and to give anti-gun extremists what they need economically to eviscerate lawful gun manufacturers and retailers. And by the way, we should note that courts have consistently held that the underlying law in question here is, in fact, constitutional. Even the liberal Ninth Circuit Court of Appeals has rejected a separation of powers challenge, an equal protection challenge, substantive and procedural due process challenges, and takings challenge related to the PLCAA. It remains good policy today. I urge my colleagues to vote against this legislation that would repeal that good law from a few years ago. And with that, I yield back.
Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2814.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. This amendment in the nature of a substitute makes a minor change to the title of the bill, renaming it the Equal Access to Justice for Victims of Gun Violence Act of 2022. Otherwise, it does not change the substance of the bill in any way. I urge all members to support this amendment, and I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute?
Got it. It's my vote.
Are there any amendments?
Mr. Chairman,
Ms. Jackson Lee?
Mr. Chairman,
Ms. Jackson Lee?
just want to put my statement in the record. Ask unanimous consent. Mr. Chairman,
all
let me
statements
just
will be put in the
briefly say
record by
this is-
unanimous consent. Mr. Massey, Ms.
this is
McBath,
the-
Ms. McBath,
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you. 6,111. 6,111. That's the number of days survivors and families in this country have gone without justice. 6,111 days without accountability, without closure, and without healing. And might I say that some of you are actually here today. In October of 2005, PLACA was signed into law, the Protection of Lawful Commerce in Arms Act, shielding firearm manufacturers from accountability for the results of their reckless marketing of guns to young people, particularly young boys and men. But how were the victims of mass shootings shielded? How were the victims of Uvalde shielded from the bullets that ravaged 19 young bodies? And how was my own son, Jordan Davis, just 17 years old, shielded? For the past 16 plus years, we have allowed gun manufacturers to get away with selling weapons of war that have bloodied America's streets, the bodies of our children and our loved ones. Why was PLACA lobbied for so hard in the first place? Because just a year prior, the assault weapons ban of 1994 expired, allowing weapons of the battlefield to invade our communities, and with that, a corresponding rise in mass shootings, which resulted. Because the gun industry knew that they would rightly be held accountable for these assaults on our children, our families, and on our own public safety. When my son Jordan Davis was murdered by a man with a gun, my family and I were able to receive justice for his horrific slaying. But most families are really not that lucky. And often in mass shootings, the gunman usually takes his own life, leaving them unable to be charged and convicted by a court of law. So what do these families do? Simply feel assured by the thoughts and prayers of our colleagues on the right? We as members of this body have a duty to restore justice to these families and every family by repealing PLACA. We must not allow another day to go by where politicians continue to place special interests above the public safety of Americans. Americans deserve better than this. And I yield back the balance of my time.
Would the gentlelady yield?
Yes, I yield.
I just want to, I thank the gentlelady for yielding. I just want to point out that under the principles of civil justice, if a car manufacturer manufactures cars that tend to blow up or tend to crash, if a washing machine manufacturer manufactures washing machines that tend to scald the operator of the washing machine, they are liable in civil justice they're liable in court for the damages. Similarly, gun manufacturers, if their products foreseeably damage people as they do, they should be liable too, just as car manufacturers or washing machine manufacturers. The Act of 2005, the PLCAA, said that they uniquely among manufacturers and parties in this country should not be held liable for the foreseeable consequences of their negligence. The point of this bill is that everyone should be held accountable for the foreseeable consequences of their negligence, not just washing machine manufacturers or car manufacturers, but gun manufacturers too. They are no different than anybody else. If they are negligent, they should pay the price. The PLCAA, for reasons of lobbying power, because the NRA had the ability to do it, cut out the gun industry alone of all industries and said they are not liable for the foreseeable consequences of their negligence. This bill changes that, as it should, because everyone whoever they are, should be liable for the foreseeable consequences of their own negligence. I thank the gentlelady for yielding. I yield back to her.
And I'm out of time.
Gentlelady yields
Yield.
back. What purpose does Mr. Massey seek recognition?
I have an amendment at the desk.
Clerk will report the amendment.
I reserve a point of order, Mr. Chairman.
The order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 2814, offered by Mr. Massey of Kentucky. At the end of the amendment in the nature of a substitute, add the following. Section 4, effective date. This act and the amendments made by this act shall not take effect unless Section 319F3 of the Public Health Service Act is repealed.
Does the gentleman insist on his? Oh, gentleman has 5 minutes to explain his amendment.
You know, I just heard the chairman say that everyone everywhere should be responsible for their negligence. And I've also heard President Biden say that the gun manufacturer is the only industry that can't be sued. Well, I agree with the chairman, but I disagree with President Biden. President Biden is wrong, the chairman is right, that everyone everywhere should be responsible for their negligence. Let me tell you what's happening right now. There's something called the PrEP Act, which says that anybody, basically says anybody who does harm to anybody else can't be sued if they were doing it because of the pandemic. So I have a constituent who went to the hospital and got a COVID test. They stuck the swab so far up her nose that she had cerebral fluid leaking from the membrane that surrounds her brain. She got a lawyer. She asserted her rights for their negligence of sticking this literally almost into her brain and all the complications that ensued from that. She has no case. Thrown out PrEP Act. There's no liability to the hospital who stuck that literally through the membrane that surrounds her brain and caused that fluid to leak out. Another story from Kentucky. A mom, she's not an anti-vaxxer. She took her kids to get a flu vaccine, took them to the pharmacy. The pharmacy screwed up, gave them adult doses of the COVID vaccine. This was even before it was approved for children. Pharmacy calls up, oh, sorry about that. PrEP Act, though, don't bother suing us. Nobody's responsible for their liability now. It's literally like martial law.
The gentleman yield?
Yes, I will.
The gentleman is incorrect. Under civil law, if they were negligent, they can be sued.
You would hope so, but I know that's what I thought too. But not under the PrEP Act. You cannot sue. In fact, this has gotten so bad, they're starting to try and use it as an excuse for when they're negligent against nursing home residents. Oh, here's some of the things they're trying now. Oh yeah, there was water on the floor and they slipped and broke their hip and you know, they may never come back, they may never recover from this, but we were so busy taking care of COVID that we couldn't clean up the water on the floor. They are abusing the PrEP Act in the courts, but the PrEP Act itself is an abuse. And if the chairman believes what he said, that everyone everywhere should be responsible for their liability, and if he believes in the rights of people to be made whole when they are injured, and I'm not talking about the kind of liability even you're talking about for gun manufacturers. The gun manufacturers make a product that functions. It's not defective. They can be sued for defective products. Their products are not defective, but in this case, under the PrEP Act, you can get away with murder, and the family can't do anything about it. So my amendment is very simple. It just says, when you implement your new accountability bill, you call it equal access to justice for victims. Let's give equal access to justice for the victims of the people who suffered from medical malpractice. And this is important because otherwise there's no incentive. The incentive to do the right thing goes away.
when you absolve them of all negligent liability, as we've done with the PrEP Act. It's disgusting, it's abhorrent, it's not American, and it's the least that we could do for these people who are suffering and can't get their day in court. And I yield back.
Does the gentleman insist on his point of order?
I do not, Mr. Chairman.
Gentleman does not insist on his point of order. Who else seeks recognition?
Mr. Chairman, I move to strike the last word.
For what purpose does the gentlelady from Texas seek recognition?
Move to strike the last word and speak.
Gentlelady is recognized.
Thank you, Mr. Chairman. I want to speak against the amendment. I mean, this is not about the pandemic. This is not about vaccines. This is about an immunity that was given to the manufacturers years ago. And, you know, Mr. Chairman, one of the things I learned even before I went to law school or even before I became a judge was that everyone deserves their day in court. Plain and simple. If you are harmed or injured in any way, yes, the other party should be held accountable, and yes, you deserve a day in court. But just as the assault weapons ban expired, a Republican-led Congress passed the misnamed Protection of Lawful Commerce in Arms Act. How convenient. Just as it expired. This act effectively prevented gun violence victims from holding manufacturers and dealers accountable for negligent business practices that enabled gun trafficking. But everyone deserves their day in court. But current law has practically closed the courthouse door to victims of municipal leaders seeking redress from the courts for the harm caused by gun violence. Most civil suits in state and federal courts against firearms industry are prohibited. This immunity has been a flawed policy since its inception because everyone deserves their day in court. This law that they passed was simply a gift to the NRA from unscrupulous lawmakers in exchange for political support. The Equal Access to Justice Victims of Gun Violence Act will repeal this unjust impunity by restoring well-established legal principles like negligence and product liability. If my colleagues firmly believe gun manufacturers are incapable of wrongdoing as a matter of fact, well then let's let them go to court and prove that, because we would let them go because we believe everyone deserves their day in court. I'm proud to support this legislation, and I thank the sponsor and Mr. Chairman for bringing it forward. And I ask all my colleagues to take a stand and side with the victims of gun violence, not its enablers. Take a stand and make sure that everyone gets the day they deserve in court. With that, Mr. Chairman, I yield back.
Gentlelady yields back. For what purpose does Mr. Buck seek recognition?
Move to strike last word.
Gentleman is recognized.
I thank the chair, and Mr. Chairman, I want to do this with all due respect, but I believe that your legal analysis is incorrect, and I want to cite the PLCCA, PLCAA, and just correct you. A gun manufacturer can be sued, just as a car manufacturer can be sued for a design defect or a manufacturing defect. And I read from the statute, the PLCAA allows plaintiff to raise a design or manufacturing defect claim so long as, 1, the injury resulted directly from the design or manufacturing defect, and 2, the firearm was used as intended or in a reasonably foreseeable manner. So if a car manufacturer produces a car and the car is used to run down people in a parade, for example, that car manufacturer cannot be sued because there wasn't a design defect or a manufacturing defect. If a gun is used to fire a bullet, and yet the person who drives the car can be charged criminally and can be sued civilly for, in the case of the car, an intentional tort, and the car manufacturer cannot be sued, or at least it would not be, can be sued, but it would not be upheld in a court of law. The gun manufacturer produces a gun without a defect manufacturing or design and cannot be sued for a gun being used in an evil way by an evil person. They are identical in how they are treated under civil law. The idea that somehow we should allow an evil person to drive a car and create liability for Ford or Chevrolet, or we should allow an evil person to use a gun and create liability for a gun manufacturer is absurd. And the only reason you're doing this is to try to punish gun manufacturers who create millions of weapons that are used by lawful citizens in lawful ways so that you can shut down a gun industry. It has nothing to do with giving anybody a day in court. You don't get a day in court for a legally produced product being used in an evil manner. That is not a day in court. That is punitive. And the only reason you're being punitive is because it's a gun. And it goes to the very motive of what you're doing in these hearings today. You're trying to punish gun manufacturers because you have the agenda to take away guns from lawful citizens in this country. And what you want to do is you want to make sure that gun manufacturers can't produce any guns in this country, because your vision of the world, and I'm saying not you, Mr. Chairman, but your party's vision of the world is that we would be better off if we didn't have any guns in this country. And that is the direction that you want to move. And you think that a bill that punishes gun manufacturers will move us in that direction. A misstatement of the law would suggest that a gun manufacturer can be sued for an act that is not foreseeable. And we don't allow that in any other manufacturing situation. We shouldn't allow it for gun manufacturers. And I think that this bill goes to the true motive of the Democrat Party's gun control efforts more than any other legislation that I've seen. And I would yield to my friend from Arizona for his comments.
I thank the gentleman for yielding. And I'll just tell you that when we start talking about the exceptions that allowed gun manufacturers to be sued, we're talking, number one, about a manufacturing defect. A manufacturing defect is when the product itself deviates from the specifications in construction or quality. And usually it requires some kind of unreasonably dangerous outcome. That's what a manufacturing defect would be. That doesn't happen in a normal gun usage. If someone is negligent with a gun, somebody accidentally shoots themselves, that would not necessarily be a manufacturing defect, unless it was manufactured so the safety didn't work or something like that and deviated from the specifications. Similarly, a design defect is if there's something that's so fundamentally wrong with the product's design that it causes the unreasonable risk of injury. Without that, either one of those, no product manufacturer is going to be liable and subject to liability.
Gentleman yields back. For what purposes gentleman from Rhode Island seek recognition?
I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I want to first say thank you for bringing this important bill to markup. For over 16 years, the Protection of Lawful Commerce in Arms Act has shielded the gun industry from accountability, protecting manufacturers, distributors, dealers, and importers from facing the gruesome consequences that flow from their harmful products or their harmful conduct. Producing profits so high that Smith & Wesson, as an example, gave employees a commemorative coin to mark their first $100 million month in October 2020. From big tobacco to auto manufacturers to construction firms, every industry in this country can be held accountable for their negligence, except for the gun industry. Why, you ask?
Would the gentleman yield?
2005, no, I will not. We're
Would
going
the
to have plenty of
gentleman
time
yield?
to talk. I'm going to finish with my remarks. In 2005, a Republican-led Congress passed the PLCAA. The victims of gun violence, their families, and their communities have been blocked from holding gun manufacturers, dealers, distributors, and importers accountable. H.R. 2814, the Equal Access to Justice of Gun Violence Act, looks to right this wrong by repealing the PLCAA and enabling gun violence victims to pursue justice in a court of law. The PLCAA keeps middle and working class Americans who already cannot afford the harm they've suffered due to gun violence from being compensated for the harm committed against them. And it rewards bad actors by giving them blanket immunity that doesn't exist anywhere else. PLCAA created a race to the bottom, rewarding the companies that cut corners and act irresponsibly, and disadvantaged companies that prioritize safety and reasonableness in their business decisions. Today's gun industry innovates for lethality, not safety. They design their guns to be more concealable, more powerful, and more maneuverable in close quarters like classrooms and nightclubs. They market their guns with militarized images and language. Their targeted audiences, however, are not military personnel. It's the average American family and their children. Safety standards in America, not only created by Congress or through regulations, our civil justice system encourages safety innovation and sets new standards in industries that deeply affect the lives of the American people. We do it in the pharmaceutical area and transportation as examples. By banning lawsuits against gun manufacturers, the PLCAA prevented nearly a generation of firearms safety innovation. PLCAA barred cases grounded in well-accepted legal principles, including negligence, products liability, and public nuisance. Before it was passed, courts had made clear that the gun industry is obligated to use reasonable care in selling and designing their product like everyone else in society. When a harm is foreseeable and the dealer or manufacturer is in a place to stop or mitigate the harm, but they do not, they should be held legally responsible. American families should not bear both the risks and the costs of the sale of an inherently deadly product. This includes when dealers and manufacturers are putting products into the stream of commerce that they know or should know are unsafe for kids or are being sold to gun traffickers. There's no reason why Americans should not have the opportunity to hold gun manufacturers accountable for unlawful conduct that causes foreseeable consequences in our communities. By repealing PLCAA and passing H.R. 2814, we reopen the courthouse doors and empower the victims of gun violence to hold wrongdoers accountable. The founders trusted us to resolve differences before a jury of their peers. This constitutional right exists to ensure that every American, no matter how much money they make, their level of education or their background, has a fair day in court. To those who are seeking to scare the American people with threats of a deluge of gun litigation or so-called frivolous lawsuits, I encourage you to think about the cases that could never be brought, whose victims will never be able to seek justice. Cooper Roberts is an 8-year-old boy who lost the use of his legs in a mass shooting at the 4th of July parade in Highland Park, Illinois. Stefan Moten was 18 years old when he was paralyzed in the Aurora, Colorado movie theater shooting that left 12 people dead. Congress, when it passed PLCAA, left victims and their families bearing the cost of the gun violence epidemic or rewarding the firearm industry with billions of dollars in profit. There are so many people who have been denied their right as American citizens to hold the gun industry accountable. It's time for that to change. I urge my colleagues to support the underlying bill, and I yield back.
Mr. Chairman.
The gentleman yields back. For our purposes, Mr. Jordan seek recognition.
Strike the last word, Mr. Chairman.
Gentleman is
You
recognized.
make a defective product, you can be sued. You're negligent, you can be sued. You produce a gun that's illegal, and you sell that gun that's used in some activity, you can be sued. That is the current state of the law. There's no ifs, ands, buts about that. And every industry is held accountable if they do things like that. If they have a defective product, if they're negligent, they can be held accountable, except what Mr. Massey pointed out in his amendment. Except what Mr. Massey pointed out. That's why his amendment's right on target. That's the one area where you can't. That's why we should adopt, if they're really concerned about dealing with an industry that can't be sued or areas that can't be sued, when there's been wrong done, negligence and harm done to an individual, done to, in this case, constituents of Mr. Massey, if we're really concerned about that, we should adopt his amendment. That I yield time to the gentleman from Kentucky.
You know, what I realize here is on the other side of the aisle, we're going to hear a lot of prepared speeches. And the words that are going to come up, they've already come up. Blanket immunity that exists nowhere else. They're going to say that. They're going to say that everybody deserves their day in court. And they're going to say that while they're talking about my amendment. It sounds like they're supporting my amendment. I got excited there when I heard Mr. Cicilline give his speech because I thought he was talking about my amendment. He said nobody, this blanket immunity exists nowhere else, but he's not. And I'm afraid what we're going to hear here today are just prepared speeches that are going to have platitudes and they're going to sound great, but they're not even going to talk about my amendment. They're trying to sweep it under the rug, that people are getting harmed. There is no liability, not for unforeseeable things like they're trying to do in the underlying bill, but for the immediate and foreseeable malpractice that happens every day, and people are suffering in everybody's congressional district, and they cannot get their day in court. And that is wrong, and that's what my amendment seeks to fix. And I yield back to Mr. Jordan.
Yield to the gentleman from Colorado.
I thank the gentleman. Mr. Cicilline, come on. I think that's what Joe Biden saying, actually, or President Biden saying.
No, I was hoping to have a chance to
But
respond to your question.
So,
Yeah. If the gentleman would yield, I'd like to, you asked a question of me, I think.
no, I didn't ask a question. I was just saying, come on. That's not a question.
Oh, I'm sorry.
It was
I thought
come on without a question mark, not with a question mark.
I'm sorry.
So if somebody takes a car and commits an evil act and runs somebody down or runs a group of people down intentionally, you cannot hold the car manufacturer responsible. That is not a foreseeable use of that car. If someone takes a gun and goes into a school and in just pure evil act, kills somebody or kills a group of people in that school, you can't hold the gun manufacturer liable. It is just common sense. What you're trying to suggest is that every illegal use of a gun, whether it's on the streets of Chicago or in a school in Texas, every illegal use of a gun should be paid for by a gun manufacturer and not hold the individual responsible. That is absolutely inappropriate. It's not the law. And if the gentleman from Ohio would allow me, I'll let Mr. Cicilline answer. Yep.
Yeah, thank you. I thank the gentleman for yielding. So the exception that exists in the existing statute says a legal action for death, physical injuries, or property damage resulting directly from a defect in design or manufacture of the product when used as intended or in a reasonably foreseeable manner, unless the firearm was used in an intentional criminal act. As a result of that limitation, there is not a single case where the breach of contract, warranty, or defect in design exception that has allowed a single victim of gun violence to recover. And part of the reason, here's one example, just to give you an example.
Let me stop you there before you go on, just so I can ask another question. So are you suggesting that it was a design defect or a defect in manufacturing that caused Uvalde?
No, I'm going to give you an example right here. This is one example. This is a case, Adamus versus Sheehan, where two young people were playing with a firearm. The gun discharged and injured one of them. They sued because there was not proper notice that there was a bullet remaining in the chamber, and that was a design defect. The court ruled, because one of the boys was charged with involuntary manslaughter, that they were barred under PLCAA. So he couldn't recover anything.
Okay,
so
with
that's
18 seconds left, let me answer my question. Are you suggesting that Uvalde, a lawsuit should be allowed because there was a design defect or a manufacturing defect in the gun?
I'm suggesting anyone who has the claim ought to have their day in court to make that case.
You didn't answer that.
You didn't answer. You know what happened.
I don't know all the facts, but I
don't know
right
the facts of
I don't
Uvalde?
know all the facts that led up to those events. All I'm saying is they're denied their day in court because the Republicans gave them blanket immunity.
Time of the gentleman has expired. For what purpose does Ms. Scanlon seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Thank you. 15 years ago, the gun industry was given special immunity from lawsuits that left victims of gun violence and their families unable to utilize the courts to hold gun manufacturers, dealers, distributors, and importers accountable. Virtually no other American industry or product enjoys such protection, and the Second Amendment doesn't justify such extraordinary protection. Products such as opioids, cars, or cigarettes have legitimate legal uses, but they also have the potential to kill. Civil liability is an important tool that can promote corporate responsibility and keep Americans safe. It's why cars now have airbags and rear-view cameras, and why cigarettes and opioid manufacturers have been compelled to pay damages for misleading marketing and selling products that aren't safe for their intended use. But The PLCAA has allowed the gun industry to reap massive profits from dangerous practices and aggressive marketing without civil liability. Children are murdered at school, guns are trafficked on city streets, troubled individuals are targeted by gun manufacturers with slick marketing to persuade them that owning a gun will make them more virile or popular. Kids accidentally shoot themselves at home, and there are no civil repercussions for an industry that manufactures and aggressively markets the firearms involved. The Equal Access to Justice for Victims of Gun Violence Act will end this harmful policy and restore the rights of Americans to have their day in court and to require the gun industry to use reasonable care in selling, designing, and marketing its products. The gun industry should bear the consequences of the epidemic of violence it's helped to create and perpetrate. I encourage all my colleagues to vote to pass this bill out of committee today. I think the amendment that we're currently considering has nothing to do with this underlying issue, and I yield back.
The gentlelady yields back. The gentlelady yields back for what purposes Ms. Sparks seek recognition.
I move to strike the last word.
Gentlelady is recognized.
Thank you. I'm not an attorney, so I was trying to figure out why would we even have this really discussion and why we would have the debate about something that doesn't make sense because we don't sue if somebody decides to kill someone with a car, if someone would decide to kill someone with a knife, just to sue that would be pretty strange to me. Why would we have that? So I read this, what we actually, the protection is, and it says, that specifically it gives immunity if somebody is in unlawful misuse of qualified product or criminal use of it. And I was thinking myself, and it specifically says it doesn't apply if there is something convictions, if there is something negligence, and if there is some manufacturer violated any federal or state law. So it really doesn't give protections. I was thinking, why in the world we even do that? Because I don't know how you can even argue in court about these issues. So in reality, this is really an issue that could only benefit, to tell you the truth, trial lawyers, because you cannot win and say that if I did nothing wrong and you use my car or my gun or anything. So in reality, all it does, it just wants trial lawyers to make a lot of money and be able to, drain the money from manufacturers. It does anything else because it's really dealing with criminal activity. That's it. So victims are going to get nothing for that. It's a pure money-making machine for trial lawyers and bankrupting gun manufacturers. That's the whole intent of this. And unfortunately, we now created an environment when a lot of attorneys are abusing the system and make a lot of money and making these frivolous lawsuits because it doesn't even make sense. On contrary, when we're talking about the vaccines, the exception is actually pretty broad. Unless I want to kill you with willful misconduct, I am pretty much immune, even if I do something bad and negligent. And I think that is actually a very dangerous way to do that. That is a very broad liability that is actually a big problem, and we should revisit it. And this is because we do need to have a system. If something happened wrong, and I, as a producer, do something negligently, you should have liability. That's the best way to go to the court. But if somebody's criminally using, something, whatever it is, it could be gun, it could be car, it could be vaccine to kill someone, you cannot say that, there is something that I would be liable for. I don't think you can even make your case in court. You have to be crazy as the judge to rule something like that. It's a purely benefit trial lawyers and doesn't benefit victims. So let's not talk about that this has anything to do, because any negligence, it specifically says that it's not covered. If something manufactured is done wrong, they're not exempt. I think it's even strange that we created now an environment that we need to have that. We need to have this protection because it's not common sense. But unfortunately, we have too many shrewd lawyers that try now to bankrupt industry without really protecting consumer. And in reality, people get nothing from that, and they get dragged down into politics and money-making machine and very shrewd attorneys
that have nothing to do, and victims get nothing from the end, because it's unbelievable that you can even get something to that, as a part of result of some lawsuits, because it just, common sense doesn't work like that. And no judge would say that if I want to go use whatever weapon I want, whether it's vaccine, whether it's a car, whether I take the picture from the wall and decide to hit you on the head and I kill you, what should I sue the painter? I mean, it just doesn't make sense. Totally doesn't make sense. So I think this is very strange that we even have these arguments, but it is traceability and all different laws that we did that create environment now where attorney can misuse and abuse the system and not protect the victims, but benefit and enrich themselves and the stake of pure people that maybe struggle in some issues that happen. Instead of dealing with gun violence and drug manufacturers and actually dealing with crimes on our border, instead of dealing with the cities and help to deal with the real situation of criminals, we actually taking rights from law-abiding citizens that should be able to protect themselves. Because I think we're creating now a situation that we need to really seriously think in some of the cities, including my city of Indianapolis, has higher per capita rate of crimes than Chicago. And I think this is a big problem, and we have to have better law enforcement and not have this anarchy, and people need to be able to protect themselves. So taking rights from law-abiding citizens and bankrupting the company that do nothing wrong, it's just really unconstitutional. It's unfortunate that we are doing it. I yield back.
The gentlelady yields back. For what purpose does the gentlelady from Georgia seek recognition?
Mr. Chair, I move to strike the last word.
Gentlelady is recognized.
Just very briefly, in response to comments concerning the PrEP Act, the PrEP Act is temporary and applies during a health emergency for health workers. Moreover, the GOP was pushing a permanent liability shielding for COVID-related harms for every industry. And with that, I'd like to go ahead and yield the balance of my time to my colleague, Mr. Cicilline.
I thank the gentlelady for yielding. I just want to underscore that the statute currently creates such a high bar that it's virtually impossible for victims of gun violence to recover despite the reckless or negligent or even intentional conduct of a gun manufacturer. And that's what this legislation is designed to correct. One has to wonder, why did the gun lobby think they needed to have Congress give them some special protection from lawsuits? Could it be maybe that they were engaging in behavior that was causing significant harm and they wanted to protect themselves from being responsible for the costs associated with that harm, despite the fact that every other industry in America is responsible for the harm that they cause? The answer is yes. In other industries, businesses owe a duty of care to the clients and to the greater public. It's one of the bedrocks of our American system of jurisprudence. And it was established to ensure that injured parties who are harmed have an ability to both be compensated as well as to deter others from committing harmful conduct in the future. In every state, a business or an individual can be sued for their negligence when their conduct lacks reasonable care that foreseeably results in harm to others. But the PLCAA creates a protective shield for the gun lobby, for the gun industry, so that they're not responsible for the harm that flows from the products that they develop and sell and market. And, there are so many examples of people trying to seek compensation from the gun industry for the harms that have flowed that would otherwise have a right to be heard in court until the PLCAA is invoked and they can't overcome that hurdle. That's what this bill will correct. And if you think they're invalid claims, the gun lobby will prevail in a motion for summary judgment. But it gives the American people, gives people who have suffered unspeakable harm and loss some ability to be compensated by those that are responsible for the harm that was caused. And this is so central. We're on the Judiciary Committee. This is central.
Could the gentleman yield?
Yes, of course.
Or Ms. McBath yield for a question?
I'll yield back to Ms. McBath, and then she can yield.
I yield.
Thank you, Ms. McBath, and for your leadership. Is there any truth to the gentlelady from Indiana's claim that this will just benefit lawyers and not the people they're representing? Would this override state laws governing the distribution of damages or tort law? Doesn't this just restore state laws that have been preempted by this legislation?
Yes.
Yes. Yes, it does.
I thought so.
The gentleman yield. Would the gentleman yield, or gentle lady yield?
Is my colleague from Maryland, would you like more time, or?
Yeah, well, I look, I didn't understand the point that this was going to benefit trial lawyers rather than plaintiffs. The trial lawyers only make money when the plaintiffs win. Right now, it's the plaintiffs' claims that are being extinguished by this massive act of federal preemption of state laws. Why would we crush state laws for one industry in this way? What's so special about the gun industry that they shouldn't have to go through normal state tort laws and product liability laws and every other kind of laws that every other industry does?
Sounds like the gentleman supports my amendment.
No. Would the gentlelady yield?
And let me just say one more thing. From a survivor standpoint, the question was asked, does this give just, money in the pockets to lawyers and attorneys? As a survivor, this gives us relief. As a survivor, and I think I can speak for the survivors, and they might agree with me, those that are left here tonight, that it gives us some sense of hope that there is accountability for the negligence and the actions of gun manufacturers to market to males, to market to young people, gives us some sense of hope that there is some sense of sanity moving forward and our ability to be able to have accountability held by manufacturers, the NRA gun lobby, gun sellers. I mean, let's talk about how, let's go down the whole line here of all the accountability. But it does give us some sense of relief that there is a group of individuals and people and a climate that really cares about the number of people that are dying unnecessarily due to the unnecessary gun violence. I yield back.
Gentlelady yields back.
Mr. Chairman.
Who seeks recognition?
Mr. Chairman,
For what purpose does Mr. Biggs seek recognition?
move strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I want to cover 3 points real quickly. We've heard repeatedly that the PLCAA was a Republican bill. It was actually a bipartisan bill, 50 Rs, 14 Ds in the Senate, and 223 Rs and 59 Ds in the House. It's a bipartisan bill. So what we've heard from President Biden repeatedly is that, and we've heard some of it tonight, that you can't sue, that the gun manufacturers are exempt from lawsuit, and that this is going to open it up. Well, here's the deal. Gun manufacturers are not entirely exempt from being sued, nor are they the only industry with some liability protections, as we've heard alluded to as well. Under the PLCAA, manufacturers cannot be held liable for the use of their products in a crime. That's specified. However, they can still be held liable for a range of things, including negligence, breach of contract regarding purchase, certain damages from defects in design or manufacture of the gun. In fact, cases have gone forward. The Sandy Hook case, in 2019, the Supreme Court there allowed a lawsuit manufacturer, Remington Arms Company, to continue. That lawsuit continued. As a result, they offered $33 million in settlement. But ultimately, that kept going, and where they were held responsible was the marketing practices, ultimately settling for $73 million. So I don't think you should say that they're exempt. Remington paid $73 million and is looking to remain afloat because they may go bankrupt now. Other industries, though, also have exemptions in liability. Vaccine manufacturers cannot be held liable in a civil suit for damages for vaccine-related injury or death. And for the next 4 years, pharmaceutical companies developing COVID-19 vaccines will also have immunity from liability under the PrEP Act, as Mr. Massey has talked about. Those who claim to have been harmed by vaccines may receive money from the government, but not the pharmaceutical company via the Vaccine Injury Compensation Program. And Mr. Chairman, I would like to introduce into the record 3 pieces. One is from PolitiFact, Biden wrong on claim about gun manufacturers and liability protections. Number 2 is CNN, Politics, Facts First, Biden wrong, claim false. And a piece by D'Angelo Gore, Biden repeats false claims at gun violence meeting at factcheck.org. And with that,
Without objection.
thank you, and I'll yield to the gentleman from Colorado.
I thank the gentleman for yielding. I hope my friend from Rhode Island remembers Operation Choke Point. That was the last time that the Democrats tried to put the gun industry out of business. They used the banking industry to try to cut off credit and prohibit bank transactions by using a completely different agency, the FDIC, the federal oversight of our bank system in this country, our finance system in this country. And the Democrats are trying to do the same thing now with this bill. This isn't about victims. This isn't about empowering victims to sue. You know there are no, that the Uvalde case was not a foreseeable use of that gun. That was an evil use of the gun. And there are millions of people who have a similar gun and use it lawfully. And to suggest that one person using that gun or one person using a car to commit an evil act somehow makes a manufacturer liable. This is simply an opportunity to open a floodgate of lawsuits against gun manufacturers when they have done absolutely nothing wrong in the act, the terrible school shooting, the terrible shooting on July 4th, the other evil acts that have occurred. So let's not pretend today that this is a bill that is going to empower victims and give them their day in court. This is just another attempt, just like Operation Choke Point, to punish gun manufacturers for doing something that has been done for hundreds of years, manufacture weapons so that people can defend themselves, so people can hunt, so people can enjoy other shooting sports. And somehow we're going to turn that into an effort to shut down the gun industry. It's wrong. I yield back to my friend from Arizona.
I'll yield back. Thank you, Mr. Chairman.
Gentleman yields back. For what purpose does the gentlelady from Texas seek recognition?
Mr. Chairman,
Jackson Lee.
To strike the last word.
Gentlelady's recognized.
sorry, I thought it was this Texan.
To strike the last word. First of all, let me say that I lived through the passage originally of this legislation, and I oppose the underlying amendment and rise to support 2814, the equal access to justice for victims of gun violence, which would unlock the doors of courtrooms in every corner of America and allow victims of gun violence to hold gun manufacturers and merchants accountable after years of recklessness and indifference. I have an article here from New York Times I'd like to submit into the record. Video deepens Uvalde family's pain as questions on response remain. The question is, thank you. The question is, of course, the underlying is a question of recklessness and how gun manufacturers should be held accountable. That's for the court to decide. The provision that we are repealing, and I thank Congressman Schiff for offering it, closes the door to the courtroom. This legislation would repeal provisions of the Protection of Lawful Commerce in Arms Act, commonly known as PLACA, and invalidate the Tiahrt Amendment that have allowed the gun industry to act with impunity, frankly, recklessly. It is fitting that we consider this legislation today on the 10th anniversary of Aurora, Colorado shooting. Lonnie and Sandy Phillips were ordered to pay more than $200,000 attorney fees to the company that sold 4,000 bullets in a single sale to a man who murdered their daughter, Jessica. They were ordered to pay money in attorney's fees after their case was summarily dismissed pursuant to PLACA immunity. How outrageous. In what system of justice is that outcome fair? Can you imagine compounding the pain of those parents? There are probably many cases like the Phillips that I'm sure we all know. Nevertheless, today is a good day. Today we can begin the process of removing the 17-year-old cloak of immunity or invisibility that Congress draped over the shoulders of every gun manufacturer and merchant in America. They became the elite. They could not be touched. For yet several years, I stood against this legislation alongside Chairman Nadler and Immigration Subcommittee Chair Lawford. We knew then the likelihood of what has come to pass in our communities since the legislation was enacted. I can recall saying on the floor during the debate, Mr. Speaker, this is a bad bill. It's bad then, it's bad today, it'll be bad tomorrow unless we repeal it. Then on the day the bill was signed into law, Wayne LaPierre of the NRA had the audacity to say, this is the most significant piece of pro-gun legislation in 20 years. We were both correct. Pro-gun, make money, continue to do and kill with impunity. This bill was a bad bill for the American people and a great bill for the gun industry, trending higher since 2005. Gun sales boomed during the Obama administration. The number of guns manufactured nearly tripled over the past 2 decades, from 3.9 million in 2000 to 11.3 million in 2020. And last year, the gun and ammunition industry accounted for as much as $750 billion in economic activity in this country. I think the perpetrator in Uvalde had 350 pounds of ammunition, at least an outlandish amount, if not that. The extraordinary economic growth of the gun industry comes at a tragic cost to communities across the country. Federal, state, and local governments spend a combined average of $34.8 million each day to respond to the effects of gun violence with no contribution from gun manufacturers. You would think the people who own gun companies have children, have families, have seen gun death, and yet apparently they are happy-go-lucky not being able to be sued. Gun manufacturers and dealers, and the annual bill for taxpayers, survivors, families, employers, and communities, $280 billion. This legislation hurts the victims of gun violence. What do you expect these parents or these family members in Buffalo, the parents in Uvalde, to be able to be locked out of the courtroom? How disgraceful. The present law did not bar frivolous claims against the gun industry, as supporters of the bill claim, like it's a lawyer's bill. It's not a lawyer's bill. How dare you put up lawyers compared to the pain of those they represent? Instead, it has barred virtually all attempts to hold gun merchants responsible for claims grounded in the fundamental principles of tort liability. I've heard one of the members talk about a police state. I reject that. The United States is not going to be a police state. But what it is going to be, a denial of constitutional rights. When I go to the courthouse doors and it says no room at the inn, don't even come in, because you're suing the precious elite gun lobby, gun owners, gun manufacturers. There have been few instances of favorable judgments against gun manufacturers or merchants following the enactment of this law. Many cases have been dismissed despite the so-called exceptions that were supposed to allow meritorious claims.
Time of the gentlelady
I ask my colleagues to oppose the amendment and support the underlying bill. With that, I yield back.
Gentlelady yields back. For what purpose does the gentleman from Ohio seek recognition?
Move strike last word, Mr. Chairman.
Gentleman is recognized.
Thank you, Mr. Chairman. There's no question that this bill is yet another attack by Democrats on the Second Amendment. And as was already mentioned, back in 2005, and I was here and voted for this legislation, we passed the Protection of Lawful Commerce in Arms Act. And Mr. Cicilline before, I think, emphasized that this was a Republican-led Congress, but I want to again reiterate that there were 59 Democrats here in the House that voted for that legislation, and 14 Democratic senators also voted for that legislation, including none other than Harry Reid, who was the majority leader at the time. And for those watching at home, Harry Reid was the Chuck Schumer of his day. But can you imagine Chuck Schumer voting the way we all voted back then for that legislation, which was common sense legislation? I sure can't.
Would the gentleman yield?
Yes.
Chuck Schumer voted against it in the House.
That's what I'm saying. I can't imagine. Chuck Schumer, you're saying Chuck Schumer did?
Yes,
Harry
he did.
Harry Reid voted for it. But I'm saying, could you imagine somebody in a leadership role in the United States Senate on the Democrat side voting for that legislation back then? They'll certainly vote for this legislation here, but not that common sense legislation back then, because your party, the Democratic Party, has lurched so far to the left on so many issues. We used to talk about, and my Democratic friends even voted for money for support for border control. Now, essentially, they're for open borders, defunding the police. Not all of them, but a significant number of them are on the record for defunding the police, and today trampling all over the Second Amendment. The common sense legislation that we passed back then was a response to aggressive, politically motivated litigation that literally threatened to bankrupt and wipe out an American industry, in this case, the firearms industry. Not only was there great concern about the wave of litigation against gun manufacturers here in Congress at the federal level, but 34 states also passed similar laws. And despite challenges, courts have consistently and almost uniformly upheld those statutes. Not only would this bill repeal key sections of that bipartisan bill we passed back in 2005, but it would also make the contents of a federal firearms trace database accessible and admissible for use in civil actions, which Congress has consistently rejected over the years, as it would only further empower plaintiffs' lawyers and harm ongoing investigations. This is yet another effort by Democrats to bankrupt the firearms industry through endless, meritless lawsuits that would cripple an industry that employs more than 300,000 people in this country. This legislation would disrupt sound law. It would line the pockets of trial lawyers. It would hurt hardworking Americans. And most importantly, it would do absolutely nothing to make our communities safer. I'd urge this committee to consider legislation that would actually help make the American people safer and hold bad actors accountable. And I would yield the balance of my time to the gentlelady from Indiana, Ms. Spartz.
Thank you. I hope I agree with gentlelady from Texas that I do have a concern with police state, and I hope she's right, but there are a lot of trends, unfortunately, we see it happening more and more, and it's very concerning. But just talking about follow-up on some issues, you know, there is actually criminal unlawful misuse specifically states the immunities. There is nothing about negligence, where in case of vaccines, it's actually we are protecting some potentially bad misconduct, so it's a big difference. But I will tell you something, you know, there are two only could be goals of this bill, are the bankrupt gun manufacturers, so we don't have access to Second Amendment rights, if we just drain them through lawsuits, you know, which is hard to win, and hopefully it's settled. And unfortunately, I hate to tell you, I've been a state legislator too, and read a lot of state laws. When I say it benefits trial lawyers, for some reason, maybe they're written that way, but every time I see the cases, for some reason, lawyers get a lot of money and victims get very little. So I don't know why, I'm not an attorney, but maybe they're writing also state laws. For some reason, they benefit really and distort, you know, the system, the way how it's written, and that is unfortunate, but that's the case. I've seen it happening quite often, and thank you. I yield back.
Gentlelady yields back. For what purpose does the gentlelady from Texas seek recognition?
Mr. Chairman, I seek to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman, and once again, let's just take a deep breath and focus on what this bill is really about. It's not about some of the scare tactics that are being used, of threats of all these lawsuits and all these lawyers. It's really about making sure that we give victims a way to seek justice, a way to seek the hope that my colleague, Ms. Macbeth, has been talking about. When Congress passed this, unlimited immunity, it left victims and their families bearing the cost of the gun violence epidemic while rewarding the firearms industry with billions of dollars in profit. It was essentially a gift to the NRA. You know, and I know that someone earlier said that this was a bipartisan bill when it passed, the PLCAA, but it was also opposed in a bipartisan fashion. 140 Democrats and 4 Republicans voted against this on the floor. And they voted against it because they saw that this was going to hurt families and their right to get a day in court. You know, the founders trusted us to resolve differences before a jury of their peers. They deserve to do that. And for those who argue that the manufacturer shouldn't be dragged into court because of this and this, well, great, they can go in there before a judge and a jury and prove that case, that it's not their liability. But this bill would simply require that the firearms industry be once again broadly treated the same way as any other industry under the respective tort laws of each state and applicable federal law. There is an epidemic of gun violence in this country. States, cities, and individual Americans alleging claims that the reckless practices of the firearms industry are contributing to this epidemic of violence deserve their day in court. That's what our system about. Two sides get to argue in front of a judge or a judge and a jury, and a decision is made. This bill will give Americans, especially victims, the equal legal footing that they deserve and which they once enjoyed. And with that, I yield to my colleague, Mr. Cicilline, for the remainder of my time.
I thank the gentlelady for yielding. You know, it's important to remember that when you provide someone with blanket immunity, you discourage that company or that actor from innovating, from figuring out ways to design products more safely. All of the things that drive companies or actors to behave differently are gone because they're immune from any responsibility for their conduct.
Is the gentleman speaking about my amendment?
My colleague, Ms. Jackson-Lee, made reference to the case in Aurora, Colorado, where, and I'd like to ask unanimous consent that this article, which is sadly entitled, "My daughter was murdered in a mass shooting, then I was ordered to pay her killer's gun dealer," as into the record.
Without objection.
And in that
Without
case,
objection.
in that case, a woman's daughter was killed. She filed a lawsuit because the killer had purchased 4,000 pieces of ammunition online, and that should have put the seller on notice that something was awry. And she went to court, and not only did she not prevail because of PLACA, she was ordered to pay the gun dealer $203,000 after her daughter was murdered because of that negligence and reckless behavior. And think about this example. You have a gun manufacturer that's selling guns to a gun seller. That gun seller doesn't keep any records, sells it to criminals, has no regard for any of his or her requirements. Someone buys that gun and kills somebody. That family says, "I want to sue you. You should not have sold these or delivered these guns to this gun seller. He has a terrible record." They say, "PLACA. I can be as reckless and irresponsible, but I'm barred from suing them because there was a crime, there's an underlying crime." That's wrong. That encourages reckless and negligent behavior. It unfairly shifts all of the costs of that horrible gun violence onto the victim's family. That's just wrong. No other industry gets treatment like that, nor should they. That defies the basic principles of our jurisprudence. You behave wrongly, you pay for the harms, and it encourages you not to behave wrongly. But no, there's one special industry who 17 years ago, this was their number one priority. And then George Bush became president, and he delivered. He gave the gun manufacturing, the gun industry protection nobody else gets. And now it leaves American families to shoulder the burden of the ravages of gun violence. This is wrong. Tonight we're going to fix it.
The gentleman's time has expired. For what purpose does Mr. Roy seek recognition?
Move to strike the last word.
Gentleman is recognized.
So it just strikes me as beyond all understanding that you've got a piece of legislation that is hardly the first to say that we're going to go out and create some liability protection across an industry. We've got the Good Samaritan Food Donation Act. We've got the Volunteer Protection Act. We've got any number of pieces of legislation that deal with healthcare. We've got protection for federal employees. We've got the Safety Act, which is involving anti-terrorism. We've got Air Transportation Safety and Systems Stabilization Act in the wake of September 11th. There are times when we step in and say that, okay, maybe we need to do something here to stop frivolous litigation. And in this case, passed legislation. I was a lawyer on the Senate Judiciary Committee when that occurred. Passed legislation that spells out very specifically a number of ways where gun manufacturers can and will be held liable, right? Against someone convicted of knowingly transferring a firearm or ammunition with knowledge or reasonable cause that it will be used to commit a felony, against a seller for negligent entrustment, against a manufacturer or seller knowingly violated law applicable to the sale or marketing of the product, against a breach of contract in connection with the purchase of the product, against raising a design or manufacturing defect claim. And I think the question that I would raise is, back to the point of Mr. Massey's amendment, is why are we saying here where we've got the production of a vaccine, a shot, medicine, whatever you want to call it, that we actually have government policies and attempts to force Americans to take said vaccine. And then we have legislation under the PrEP Act where a covered person is immune from lawsuits and liability under federal and state law with respect to all claims for loss resulting from administration or use of a covered countermeasure such as COVID-19 vaccine. And we don't want to deal with that when Pfizer, just last year, Pfizer made, I can't remember the exact number, I have it right in front of me, but something like $37 billion just last year alone on COVID-19. I mean, it's extraordinary. Pfizer made nearly $37 billion in sales from its COVID-19 vaccine in 2021. I mean, maybe we should just check Paul Pelosi's stock portfolio. Maybe we'd be able to follow the stock price pretty closely. But here we are, Pfizer makes all this money, and we're allowing that, a vaccine where specifically the manufacturing of that vaccine in an unproven environment in response to a pandemic, then we're forcing through policy that people have to take. There's no liability recourse, yet we want to go to a gun manufacturer who's producing a product. We all know what it's used for. And then we laid out a procedure where you could still sue when you're talking about the manufacturing defects and a whole host of other ways. And look, my colleagues were serious about making sure that something wasn't falling through the cracks, where there's legitimate cases we might want to go pursue, where there was negligence, true negligence, that you want, well, then add another provision to it. Or just striking and sweeping it away is all borne out by what the gentlelady from Indiana was suggesting, that this is all about trying to find ways to crack through and through the civil litigation system, attack and go after gun manufacturers for producing not only a lawful product, but a lawful product that is constitutionally protected for us to own. And so you're literally saying, great, let's go open the door for massive litigation against a constitutionally protected product for us to own. But no, let's ignore Mr. Massey's suggestion here that, hey, why don't we just open up for liability, the ability of the American people to say, wait a second, vaccine makers, you guys have produced a product where if you look at the VAERS data, you've had 1.3 million adverse events reported through the VAERS system. And you've had that result in, I think there's something like 29,000 deaths. Now, understanding that VAERS is not a perfect, representation of data and scientific, but it is a government system to report the data. But we're going to ignore all that while Pfizer makes $37 billion in 1 year on COVID-19 alone. And we're going to now say, no, we're going to sue, Louisville Slugger because some jackass takes a bat and beats somebody to death. I just don't get it. I yield back.
Gentleman yields back. For what purpose does the gentleman from Maryland seek recognition?
I move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Thank you. The more I'm hearing my colleagues try to divert attention from what's really at stake here, the more convinced I am about the fundamental importance of this legislation. Look, if they have a serious complaint about the vaccine legislation, they should bring it forward as a bill. And I'd be very happy, for one, to look at it and see what they're talking about. I know that there are adverse reactions in a small number of cases to particular vaccines. And I wasn't in Congress when this happened, but I believe it was an attempt to try to deal with that issue and to set certain amounts of money that people would be compensated in the event of sickness or injury or death relating to it. But I'd be very happy to look at that and deal with those very hard questions. But they just seem to want to avoid the fact that Congress responded in a really terrible and disproportionate way when cities and towns and states suffering under a crush of gun violence were bringing litigation to do whatever they could to try to stop dealers and manufacturers from aggressively marketing weapons of war, assault weapons, firearms to criminal gang members, to deal directly in the underworld, to misrepresent the firearms, and to not do anything to take care of public safety. Why shouldn't mayors and city councils and governors and county commissioners have the right to go to court and be heard on tort lawsuits or product liability lawsuits, negligence lawsuits, recklessness lawsuits, when that's what the state law is generally, and not to have Congress come in? And I thought you guys were against that. And like King Kong, step on state laws and step on state tort law and the right of juries to determine whether or not there was real negligence or real recklessness. And that just strikes me as debunking your claim that you just want to be neutral. You don't want to be neutral. You want to enthrone and deify the gun industry. And it's, for them, it's all about profits, of course. So I think that this is essential legislation. So the gun industry, and put it differently, so specific gun dealers or manufacturers who commit torts against people and commit torts against entire communities will have to go through the great American justice system with due process for people who've been injured. So just like you can have a lot of sympathy for the gun manufacturers, what about some sympathy for the families of people who've been killed by gun violence in a grocery store or a church or a Walmart or an elementary school? It's just extraordinary to me to hear people speak with such pained identification and empathy for the gun industry and nothing for the victims of the gun industry who did nothing more than go to first grade or try to go grocery shopping for their families. So, Mr. Roy, I'm afraid my phone got cut off before when you were engaging in some response to what we were talking about in terms of our constitutional colloquy. The beginning of what I heard was you were essentially conceding the point that the Constitution is totally on the side of the government stopping insurrection in 5 different clauses, including Article 1, Section 8, Clause 15, which gives Congress the authority to call up the militia to put down insurrections. Far from the Constitution endowing any individual with the authority to engage in insurrection, the Constitution is on the side of the government, and specifically Congress and the states stopping insurrections. And so I think in the end, just when you got cut off, unfortunately, I think you were shifting over to an argument about the Declaration of Independence, which is an argument about natural law. So you're saying there is nothing in the Constitution that protects this insurrectionist ideology of the Second Amendment. And of course, it's frivolous and ridiculous. But you're saying that there, under the Declaration of Independence, there is a natural law right to overthrow tyranny. And I would concede that. I'd say that's true, but that's not a constitutional right. The Constitution doesn't give you the right to overthrow the Constitution. That's absurd. If you actually want to make revolution against the US government, that's on your time. That's at your risk. I mean, you don't even have a right to do nonviolent civil disobedience in America and do that for free. I mean, Dr. King spent many months in jail when you add it all up, because even though he was on the side of right constitutionally and morally, still, he didn't have a constitutional right to go and sit in. The civil rights movement didn't, and they were willing to pay the price for it. But what we have with the people who
time has expired. The gentleman's time has expired.
Okay.
For what purpose does the gentleman from Texas seek recognition?
Strike the last word.
Gentleman is recognized.
All right, thank you. To say, as has been said, that gun manufacturers have been given protection no one else gets, well, let's put it this way. Under the House rules, we cannot attribute false motives or intentional misrepresentation to other members. So it means it's just ignorance. You're not aware of some things, so let me help you. We've already heard about the pharmaceutical industry. Not only has the pharmaceutical industry been protected from all the harm that has been done, they don't even have to warn of the things they know are actually happening as a result of their vaccines. They're protected. You look at the warning sheet, there is nothing there, totally blank. Why? Because this body has set up laws that give them complete immunity in an emergency use authorization. They don't even have to warn people. So don't talk about, oh, they get protection no one else gets. And I'll give you another one. Social media. We've talked about this in this chamber, in this committee. They are protected from fraud, from all kinds of wrongdoing. Diamond and Silk, they paid money to have their name come up higher on the list, and an algorithm was used, sent them to the bottom. And social media was protected from those kind of lawsuits. Some of us want them to not be protected, let them be responsible for their wrongdoing, but Democrats have totally protected them because they want them to be able to continue to hurt conservatives. So, and we don't stop there. Who else is protected? Members of Congress. Because if members of Congress were not protected, there would be all kinds of lawsuits. We had over 100,000 killed in 1 year from fentanyl coming across our southern border illegally. And people in this body voted repeatedly to try to prevent our border from being secured. We've got people that have been murdered, raped, horrible crimes committed, and everybody here knew that those things were going to occur because they had been occurring, yet they said, we're not going to secure the border because we think they'll come across and vote Democrat. Whatever the reason, there would be liability in this body. Nobody could afford to be in it if there weren't total protection from people here. And what about President Biden? Could he be, if we wiped out all protection? Heck, somebody might have a successful lawsuit for him putting Kamala Harris in charge of the border, and she wouldn't even go there. She would be liable for not going there, but she's totally protected from any negligence or intentional misconduct that somebody might care to sue over. These are all things that have gone on and go on, and members of Congress have protected many groups, including ourselves. But what is at the bottom of this? The effort has been to eliminate the Second Amendment every way that can be conceived. I'm responding to the ridiculous claims that have been made here. So no, I'm not yielding. So with regard to the Second Amendment efforts to get rid of it every which way, what Democrats have seen successfully done, it's not warfare, it's called lawfare. You overwhelm people or industries with so many lawsuits, they can't stay in business. It's worked successfully, and now this committee is considering allowing that to gun manufacturers. But don't worry, we've already seen people that are in leadership positions, they'll be protected, just like in the Soviet Union. When I was over there in '73 for the summer, we were warned in orientation, look, it isn't America. The elite over there, they make all the rules, and you have to be in the elite to have a car. So you got to understand, pedestrians don't have the right of way. Pedestrians are the low life, rank and file, and they're walking, just like in medieval days. The ruling elite, they rode, everybody else walked. Oh, they'll be protected by guns, but they would actually try to run you down. It was a game. They knew they would never be held liable if they hit a pedestrian because you're a lowlife, you're a riffraff. And that's where this is headed. Progressivism, socialism, communism, whatever you want to call it, will have an elite ruling class, and we just can't let that happen.
The time of the gentleman has expired. The gentleman yields back. For what purpose does the gentleman, does Mr. Johnson of Louisiana seek recognition?
Thank you, Mr. Chairman. I wanted to yield my time to the gentlelady, Ms. Sparts.
Thank you. I just wanted to kind of talk a little bit about blanket immunity and limited immunity. Actually, someone who has unlimited blanket immunity is big tech, and we did it actually with intent to protect our First Amendment rights. And I think that is a very broad and being abused. So when we talk about protection of constitutional Second Amendment right, which is actually extremely important to have the First Amendment, this is actually not a blanket immunity. This is actually very limited immunity, which talks only in cases when somebody does something criminal, and there is specifically says there is no negligent covered or violation if knowingly manufacturer give against federal or state law to some dealer or someone does something actually specifically says in the code, you cannot use this immunity. So it's a very limited immunity. Just it seems to me it doesn't even make sense to do it. But unfortunately, we have such an assault on the constitutional right and Second Amendment rights, and it is my duty as a congresswoman to protect people's rights to life, liberty, and property, including constitutional rights. It is my duty, it is my number one duty to protect constitutional rights of my citizens, and Second Amendment right, it is one of them, and first two, and that's why actually our big tech immunity and liability now created, a lot of protection, not for the people, but for big tech, and it really became perverse. So we have to really look at that immunity and how it is abused and misused. But in this one, it's actually a very limited function where we try to protect people's rights. And it is not a state's right. It's a federal responsibility of me as a federal legislator to make sure that these rights are not infringed for law-abiding citizens. And this is what exactly it's doing it, because there is, unfortunately, infringement for a lot of different reasons. And this is a very important right. So I think we need to clarify that. But as for the other immunities, it is actually broad. A lot of vaccine manufacturers, a lot of pharmaceutical companies, they don't carry the same liability they should be, because any business should be carrying liability for doing something wrong. And that should be decided not by bureaucrats with regulations that are not enforceable, but in tort. But we're not talking the same thing. We're talking about constitutional rights protection in the very limited cases when somebody is doing something wrong, and it specifically says criminal, something doing something criminal, or unlawful misuse, somebody actually abusing something that is not intended, and specifically says all other cases, violation, it wouldn't be covered. So I think we cannot use it lightly when we're talking blanket immunity, unlimited immunity, because it is not correct. And I know that there are a lot of scholars here and looking at deep, but I read the law how it is, and I know how to read, and as a common sense person, let's not kind of mix apples and oranges, because we are not talking about the things that we have brought up by a lot of members here. And I always want to say that this is rights. It's extremely important, because if we don't have our Second Amendment rights, they protect our First Amendment rights. And it's important rights, and we can never forget about that. And we have infringement our First Amendment rights, we have infringement our Second Amendment rights, and all other rights. So I think there are a lot of rights, we get infringed. And I'm glad that some of the rights and due processes in the criminal justice system we can find bipartisan consensus. We find some maybe on our First Amendment rights in big tech, and I hopefully will have more, but I think we need to have some common sense on the Second Amendment rights too. We used to have it, and unfortunately right now, my other side, went in very radical views on the Second Amendment rights, and I hope we will wake up and someday we'll have a more constructive conversations on these issues, and I yield back.
I thank the gentlelady.
Gentlelady.
Got 58 seconds left. I just want to say she's right about our rights. And it is our fundamental freedoms that are under assault increasingly every day, and even our unalienable rights, as we keep pointing out, listed in the Declaration, beginning with the right to life. I yield to Mr. Massey.
Gentlelady yields, the gentleman yields back.
Sorry.
Oh, he yields to Mr. Massey, I'm sorry. Mr. Massey.
I had about 40 seconds left.
Look, I want to bring this back to my amendment, if I could.
Please do, sir.
Every time I hear the Democrats say, this law for gun manufacturers, it steps on state laws, I think they're talking about my amendment to repeal the PrEP Act. When they say that liability encourages manufacturers to make better products, where is that when it comes to the vaccines or the cures for COVID? It doesn't exist. And why did I offer this amendment? Because I have a constituent. She went to the hospital, and they gave her a COVID test and literally put that swab so far up into her nose that the fluid around her brain came out.
Wow.
And she has no recourse.
The time of the gentleman.
So you are.
The time of the gentleman has expired.
I yield back.
If there are no further, no one else seeks recognition, the question occurs on the amendment. All those in favor say aye.
Aye.
Opposed, nay. Nay. In the opinion of the chair, the noes have it. Recorded vote is requested. The clerk will call the roll.
Mr. Nadler,
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Johnson of Georgia?
Johnson votes no.
Mr. Johnson of Georgia votes no. Mr. Deutsch?
No.
Mr. Deutsch votes no. Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries?
No.
Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal? Ms. Stimmings?
No.
Ms. Stimmings votes no. Mr. Correa?
No.
Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath? Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
Dean votes no.
Ms. Dean votes no. Ms. Escobar?
Escobar votes no.
Ms. Escobar votes no. Mr. Jones?
No.
Mr. Jones votes no. Ms. Ross? Ms. Bush?
Bush votes no.
Ms. Bush votes no. Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert?
Aye.
Mr. Gomert votes aye. Mr. Issa?
Aye.
Mr. Issa votes aye. Mr. Buck?
Aye.
Mr. Buck votes aye. Mr. Gates?
Aye.
Mr. Gates votes aye. Mr. Johnson of Louisiana? Aye. Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stubbe? Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey?
Aye.
Mr. Massey votes aye. Mr. Roy?
Aye.
Mr. Roy votes aye. Mr. Bishop?
Aye.
Mr. Bishop votes aye. Ms. Fishbach? Ms. Fishbach votes aye. Ms. Sparts? Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes aye. Mr. Benz votes
Jayapal recorded?
Mr. Benz votes aye. Mr. Owens? Mr. Owens votes aye. Ms. Jayapal, you are not recorded.
Jayapal votes no.
Ms. Jayapal votes no.
Are there any further, Mr. Stanton? Mr. Stanton?
Yes, how am I recorded?
Mr. Stanton, you're recorded as no.
Okay. Are there any members who wish to be recorded who haven't been recorded? Clerk will report.
Mr. Chairman, there are 18 ayes and 23 noes.
The amendment is not agreed to. Are there any further amendments to the amendment in the nature of a substitute? If not, the question occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye. Aye. Opposed, no.
Aye.
In the opinion of the chair, the ayes have it. The amendment in the nature of a substitute is agreed to. Reporting.
Mr. Chairman, I ask unanimous consent request to indicate on the Biggs Amendment in H.R. 1808, I would have voted no. I was unavoidably detained, and I'd appreciate it being placed in the appropriate place of the record. I yield
Without
back.
objection. Reporting quorum being present, the question is on the motion to report the bill H.R. 2814 is amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed, no.
Aye.
No.
The ayes have it, and the bill is ordered reported favorably. Roll call is requested. The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren.
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee. Ms. Jackson Lee votes aye. Mr. Cohen.
Probably have another hearing in here before long.
Mr. Johnson of Georgia.
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch.
Good job.
Aye.
Mr. Deutsch votes aye. Ms. Bass.
Aye.
Ms. Bass votes aye. Mr. Jeffries.
Aye.
Mr. Jeffries votes aye. Mr. Cicilline. Mr. Cicilline votes aye. Mr. Swalwell.
Aye.
Mr. Swalwell votes aye. Mr. Liu.
Aye.
Mr. Liu votes aye. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Ms. Jayapal.
Aye.
Ms. Jayapal votes aye. Ms. Demmings.
Aye.
Ms. Demmings votes aye. Mr. Correa.
Aye.
Mr. Correa votes aye. Ms. Scanlon.
Aye.
Ms. Scanlon votes aye. Ms. Garcia.
Absolutely, yes.
Ms. Garcia votes yes. Mr. Neguse.
Aye.
Mr. Neguse votes aye. Ms. McBath.
Aye.
Ms. McBath votes aye. Mr. Stanton.
Aye.
Mr. Stanton votes aye. Ms. Dean.
Dean, delighted to vote aye.
Ms. Dean votes aye. Ms. Escobar.
Oops. Aye.
Ms. Escobar votes aye. Mr. Jones.
Aye.
Mr. Jones votes aye. Ms. Ross. Ms. Bush.
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan. Mr. Jordan votes no. Mr. Shabbat. Mr. Shabbat votes no. Mr. Gomert. Mr. Gomert votes no. Mr. Issa.
No.
Mr. Issa votes no. Mr. Buck. Mr. Buck votes no. Mr. Gates.
No.
Mr. Gates votes no. Mr. Johnson of Louisiana. Mr. Johnson of Louisiana votes no. Mr. Biggs. Mr. Biggs votes no. Mr. McClintock.
No.
Mr. McClintock votes no. Mr. Stubbe. Mr. Tiffany. Mr. Tiffany votes no. Mr. Massey. Mr. Massey votes no. Mr. Roy.
No.
Mr. Roy votes no. Mr. Bishop.
No.
Mr. Bishop votes no. Ms. Fishbach. Ms. Fishbach votes no. Ms. Sparts. Ms. Sparts votes no. Mr. Fitzgerald. Mr. Fitzgerald votes no. Mr. Benz. Mr. Benz votes no. Mr. Owens. Mr. Owens votes no.
Are there any members who wish to be recorded who haven't been recorded? Clerk will report. Clerk will report.
Mr. Chairman?
Ms.
Mr.
Ross?
Chairman?
Ms. Ross?
I wish to be recorded as voting aye.
Ms. Ross votes aye.
Clerk will report.
Mr. Chairman, there are 24 ayes and 18 noes.
The ayes have it, and the bill is amended as ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. This concludes our business for today. Thanks to all our members for attending. Without objection, the markup is adjourned.